everyone, and welcome to Foley and Lardner's web conference, Privileges Associated with Product Safety Teams. Today's program will run for 1 hour, and we will apply for 1 general CLE credit. Anyone wishing to receive credit for today's program must enter the code during the polling question. All New York, New Jersey, and Kansas attendees applying for CLE credit must fill out an attorney affirmation form and write down the course code. The attorney affirmation form in today's slides can be obtained in the resource list widget at the bottom of your screen. For New York attorneys, those with less than 2 years of experience will not be eligible for CLE today. Completed attorney affirmation forms should be emailed to Christina Wade at cwade@foley.com. That's CWADE@foley.com. Questions can be submitted during the web conference by entering them in the Q&A widget, which is open at the left side of your screen. The presenters will answer questions at the end as time permits. And now I'll turn it over to our first presenter, Jeff Sobel.
Hi everyone, and welcome for joining Lauren Champagne and myself for this webinar today. We're very excited to talk to you about privileges associated with product safety teams. And we're going to start by talking about product safety teams themselves a little bit. We want to talk about what sort of a product safety team is in practice and in our experience. The focus on this will be on prevention and not reaction. What to do in advance of these issues in order to maintain the privileges over your own internal investigations into product safety issues. There won't be a panacea. It's not going to be a one-size-fits-all. These are very fact-intensive fact patterns in all the cases, and the privileges often do not succeed. But we will offer at the end some practical tips for preserving the privilege, some things that we recognize as we talk about them. Many of them will be impractical. But as lawyers, of course, we can tell everybody all the steps they can take to ensure protection, but some of those won't be practical from a business standpoint. So each individual company needs to make sort of a risk assessment as to which things they can do in order to give them the best chance of protection while still continuing to operate their businesses. We'll focus in this on the 3 specific privileges, which include the attorney-client privilege, the work product doctrine, and the self-critical analysis privilege. The last one will be the one that we'll really talk about when we do some case studies in detail. The key question in all this, in trying to assert all these privileges, and you'll hear us mention this a lot as we go, is there a routine business purpose or other purpose in what the product safety team is doing? What is the purpose of it? And this question comes up because, of course, courts get very sensitive about stopping the discovery process. As everyone in this call probably knows, discovery and litigation in the U.S. is very broad. It can be very difficult to stop discovery of materials, particularly internal corporate materials, and that's what we're talking about here. Unfortunately, one of the difficulties is that this is done on a state-by-state basis pretty much. And so you really need to know the jurisdictions that your organization operates in most routinely. Obviously, I think you want to know the jurisdiction where your main business operations are, maybe where your main manufacturing facility is, and also state of incorporation if it's different. You could probably identify 3 to 5 states that you encounter the most or have the most involvement in and focus on those because, as we said, not only is it state to state, but it's very fact intensive. And lastly, we're not talking about issues that arise after a claim has been made. Once somebody has contacted your organization and said, I have a claim against your company, you owe me for property damages or personal injury, then the analysis shifts greatly. The privileges are much easier to assert, much easier to manage. So this is not at all having to do with claims arising after litigation has been started or claims have been made against the company. We'll talk about in our agenda why this is important, the product safety team, the privileges itself, the role of counsel, both in-house and outside counsel, and then we will go through 4 case studies, which I think will go a long way towards explaining just how difficult a question this is and how difficult it is to apply it in context. So we'll start with why is this important? Why does everybody care about it? And I think overarching it's important because any good organization wants to have the ability to investigate itself, to analyze itself, to look at its own products. But you want to be able to do so with the freedom of knowing that anything you say and do won't become public knowledge. When we talk about these claims, they all end up in some sort of product liability claim of one kind or another. And I think what's important here to remember when you think about your product safety teams is how broad this is. You have what I think of as the routine claims eventually that these morph into, which would be manufacturing defects, design defects, or the failure to warn. The difference is, of course, being with manufacturing, we're talking about a failure in the process of manufacturing. It could be unique to an individual product. It could also be something that impacts multiple products, for example, in a manufacturing spill on a line where 10, 15, 1,000 or more products come off with the same defect. Design defects, of course, are going to be common to the entire design. Not every product will probably fail with the design defect, but any one that is subject to design defect is something the company has to be concerned about. And I think most interesting with the design defect claims with the long tail of design is these could exist years before a product even goes into production. And they could be in documentation that is a decade or more old. With failure to warn, this, of course, is based on foreseeable uses and misuses, harms that knew or should have been known. And this is a topic in particular that safety teams, I think, are uniquely situated to tackle. And then I think we get into claims that I've always considered part of product liability, part of what a product safety team deals with. That's warranty claims and repairs or service failures. I think the warranty claims is particularly apropos these days because it's in the analysis of warranty data and warranty failures that you start to see plaintiffs' lawyers going after class action lawsuits. It also is often the most useful data to assess whether you have some sort of problem in a population of products. So a safety team may be looking at your warranty claim data more than anything else. And I think similarly with the repair and service failures, that may be something that helps you isolate an issue when your safety team is looking at it. All of these can be difficult and particularly challenging for safety teams when we break it down to sort of the key difference of what lawyers and companies look at, and that is the difference between a failure mode and a root cause. A failure mode is how something fails, and the root cause is what causes it to fail. So the most common example I use is an engine stall in any sort of vehicle, whether it be a car, a truck, or an off-road vehicle of some kind, commercial vehicle, construction vehicle. Engines are incorporated into almost every system, and the failure mode is normally relatively something easy. The engine stalled. Some simple chain of events may lead to the engine stall, but the actual root cause of why it stalled can be very complex and involve multiple different systems that interact with each other. Just getting to the failure mode is not enough. It's the root cause that we really need to get to. Why do we care? What's it matter? What are the benefits in avoiding these claims? One, we're legally required to care. There are legal liability issues, obviously, that come up. There are also regulatory requirements. If you have a product that's subject to the Consumer Product Safety Commission, that is subject to NHTSA, obviously, as this is an automotive industry call. If there are organizations whose products also get into medical devices, you have FDA regulatory requirements. So you have legal requirements to do this. On top of this, we have ethical requirements. Now, these might be subjective and they might be voluntary, but in our experience, most organizations and most people, most employees want to make the right decision. They want to be ethical. They don't want to hurt people. And you get internal benefits from doing this. You get happier employees, you get better publicity for the company, you get better goodwill. The example I always bring up is the Ford Pinto example. And 40 years ago, the Ford Pinto became a punchline that is still a punchline to people old enough to remember it. So these can have lasting, real problems when it comes to competitive advantages as to your reputation, your brand, and other corporate advantages. And then lastly, there's a simple cost savings. Your product safety teams certainly fall into the category of an ounce of prevention being much more than a pound of cure. When you have to defend a portfolio of litigation or claims, it's expensive. The legal fees are expensive. The discovery fees are astronomical. Settling them can be very expensive, materially expensive to companies. Losing cases is very expensive, in addition to having to defend them. And we're not just talking about the pure dollar cost savings. Anyone who's had an organization get embroiled in a mass action or class action knows that suddenly you have employees who are not doing their jobs of warranty supervisors or product engineers, and instead their jobs have morphed into litigation support that they spend doing a year or two. So that brings me to the product safety team, which of course is only one part of a corporate safety program. And I'm not going to talk about the other aspects. We're going to talk about the privileges associated with the product safety team. But it's important to think about the fact that this should only be one aspect of your program. It should also include employee handbooks, an online presence for your corporate safety policies, ensuring that your suppliers adhere to the same safety standards that you do, that your customers adhere to those safety standards. Those are all part of a full corporate safety package that every company should consider. As for the team itself, the first thing you've got to think about is setting it up. And it needs to be diverse. I have run into many organizations who their corporate safety committee is principally engineering, maybe compliance, but often doesn't include service departments, legal departments, sales departments, operations, your risk management, dealing with your insurers, and any other part of your company that has a say in how it operates. They should all be represented. They should all be offered a perspective here. When you do form the committee, you want to give it the right charge. What is it going to do? You want to establish criteria. How are you going to analyze these things? You want to do this objectively and not subjectively. So you want to set what failure rates for different kinds of products or subsystems are you going to be concerned about? What bevy of claims? How many do you need on the same issue in order to rise to a product safety committee issue? What sort of resolutions are you going to do? These sort of criteria need to be established in the beginning. You always want to get your best practices. You want to know what a company should do, what your own company should do in each of these situations, and you want to enforce these procedures as you go. It's not uncommon to set these things up, put them in writing, take the time and expense to do so, and then of course enforcement over time gets lax. Because you want to get something out of this. You want to not just become a safer company, but you want to learn along the way. You want your corporate safety team to evolve, to always be updating your original risk assessment management based on new information. You want to make changes. You want to alter corporate documents. Do we need to change our instructions, our warnings, and so on and so forth? You want to consider whether you need to give post-sale warnings. We've got a product already out there. Based on the information we have, are we going to give post-sale warnings to our customers? And of course, you want to consider your regulatory reporting. And this is something that I often counsel clients to be proactive. Don't wait for the regulators to come to you. I think as soon as you're in a situation where the regulators come to you instead of you go to them, you've already put yourself at a disadvantage. In my experience in working with clients and various regulating agencies, when a company goes to the regulator and says, we have identified this issue, we consider it to be safety or not safety, we have identified this fix, and we have undertaken this program, a campaign, a recall, etc., to deal with this problem, regulators are much more likely to say, okay, that all sounds good. When they come to you, that starts the process in a much more adversarial way and often leads to longer, more expensive processes. And with that, I will turn it over to, of course, the most important stuff we're going to talk about, which are the privileges themselves. And Lauren, please go forth.
Hello, everyone. So, as Jeff so nicely stated very early on in this presentation, we're going to be focusing on primarily 3 privileges: the attorney-client privilege, the work product doctrine, and the self-analysis privilege. So I'm just going to repeat this at the outset because this is going to be a part of this discussion all the way through. You really have to understand these privileges on a jurisdiction-by-jurisdiction, state-by-state level because it's going to manifest itself very differently on each level. In that vein, we've kind of tailored the presentation, so we'll talk both about how the privilege is handled on the federal level, but also on the state level. I also want you to kind of think of this as a spectrum, and you'll see that the privileges tend to get broader as we go on through the discussion in terms of what they can protect, but they also start to get a lot more complicated in how and when you can assert them. With that being said, let's first start with the attorney-client privilege. Now, I'm sure many of you are very familiar with this privilege, and it's self-explanatory. The attorney-client privilege protects legal advice between the client and their attorney. With the attorney-client privilege, under federal law, it's going to depend heavily on the role the attorney is playing. On the state law side, though, it's guided a lot by common law and usually codified in the statutes. So what we're going to do today is focus kind of on the 2 primary federal tests, which are the primary purpose and because of tests, which they're going to be articulated a little different depending on which jurisdiction you're in, but those are basically the tests the federal courts follow. And then we'll look a little bit so you understand kind of the statutory guidance and the basis for the state law rules. But I also wanted to clue you all into Federal Rule of Evidence 501 because this is one instance where you probably won't even have such a huge federal and state distinction because depending on what law is being applied on the federal level, you actually may have to be cognizant of what the state rule is because 501 requires that state law and privilege be used to make the evaluation of whether attorney-client privilege applies. So let's start with the federal level. So the first standard is a primary purpose standard. And this, again, sounds exactly the way it sounds. The primary purpose standard basically says what was the primary purpose of the document or communication. Was that primary purpose for legal advice, or was it for some other purpose? And I think this is very important, particularly for our in-house counsel on the call, because the courts are very cognizant of the fact that in-house counsel wears many hats. You have business purposes. You may have an executive position. So you're doing a lot of things that are not necessarily legally related. So when it comes to this primary purpose test, a lot of the courts are asking themselves the question, was a lawyer necessary for this task? Or could a CEO or a COO have handled this and generated this document the same way? For the because of standard, it takes it just a little bit differently. And in this case, you're looking at the totality of the circumstances, which means you're not just looking at what was the primary purpose for this document, but you're actually looking at the document and the factual circumstances around that. who wanted this document generated, who are we talking to, who's on the communication lines. All those things become more involved in the analysis, and you're getting a more fulsome review of the role the attorney is playing. But I think what is key is definitely the fact that the focus is the role of the attorney. So how does this play out? We provided here a few examples of when courts have found under either of these standards attorney-client privilege was appropriate, and when it failed. So the first three examples, I think, are kind of textbook examples of when attorney-client privilege applies. The first one, you have the in-house counsel giving advice through communications, through draft documents related to an FDA warning letter. The second, we're talking about communications between in-house counsel, outside counsel, and management, where it's very clear that legal advice is being sought or given. And the last one, which I think is going to be very interesting, especially when we start to look at where attorney-client privilege was not found, is here where you have, again, in-house counsel. They're on the communications for internal company investigation. Here, I think what is very significant about this case, in cases where attorney-client privilege has been held in these instances, is that the in-house counsel led the investigation, initiated that investigation, and then was on the communications and was actively participating in those communications. Now, if we look at where attorney-client privilege was not found, you look at one where there are non-substantive comments on drafts. And this goes back to the idea of, can a CEO or any other executive make the same kind of correction? Does this look more like a grammatical change, or is this really talking about legal substance? CCing in-house counsel. This is huge. Courts are very sensitive to using in-house or outside counsel just to preserve privilege in a way that you never intended it to be privilege. It doesn't deal with legal advice, but you want certain information hidden. So they're really sensitive to this kind of creation of privilege. So just having an attorney on the CC line is not enough. Communications on non-confidential matters. We're talking about invoices, billing, services. Usually not found. And then on these last ones, and I think this is where it gets a little complicated. Here, you're basing this on risk management reports. It's a part of an internal investigation. But even if you get past that hump, the information cannot be information that is not confidential in nature or not really being led by a lawyer and related to legal advice. So we're going to move on to how the state applies this on the state level. So the state law is usually done by statute, and then the common law interprets it in the case law for the state. So I have a couple of examples here with Virginia. Virginia is interesting because with Virginia, attorney-client privilege is established by the common law, and it's actually codified not only in their statutes, but also in the Virginia Supreme Court rules. And in those rules, it says that the attorney-client privilege is established by the common law as it is articulated in the Virginia court. And that's about all it says about the attorney-client privilege. Where if you go to Maryland, you have two statutes in the Maryland Code that very briefly establish attorney-client privilege and says that it extends to a client that cannot be forced to testify on communications between them and their client. With California, though, you have a very extensive statutory language where they allow the attorney-client privilege, but also with this privilege, there's a presumption that certain relationships create this confidential relationship. So you have attorney-client privileges within that, but they also lump that with the spousal privilege, with the doctor-client privilege. So as you can see, it manifests itself very differently. Moving on to the work product doctrine. So again, as we talk about the spectrum of privilege, work product protects documents created in anticipation of litigation. This privilege is a little narrow in the sense that it only deals with documents made after there's an anticipation of litigation. But it's much broader in the sense that instead of having to attach everything necessarily to direct communication between an attorney and a client, with the work product doctrine, you can extend it beyond, because here you're protecting the mental impressions, conclusions, and opinions and theories of the attorney, which then can extend out when you're preparing for a litigation, as I'm sure we all know, to expert reports and consultants that you bring in, employees that put together different information about the company for you. If those are led by the attorney and it is done to prepare the attorney for their legal strategy, these can also be protected. Even though the attorney didn't draft them, this can be protected under the work product doctrine. Now, as you can see on the screen, this doctrine is guided by Federal Rule 26B3B. And generally, this is the one instance where the state articulation of this rule is very similar to the federal articulation. So in many cases, states just adopt the federal rule. In other cases, there's an absolute immunity that applies to items covered under the work product doctrine. Now, I think what's also important to note about work product, and why, again, I say it's a little broader, is the materials covered here, whereas having a business purpose can be a little more tricky when we're talking about the attorney-client privilege. Courts, once you get over the hump of whether you're being prepared for litigation and this is in anticipation of a potential litigation or a potential claim, courts aren't so bothered by the fact that the document could have also served a business purpose. What I think is sometimes not always talked about, but is very important though, is when you start to think about preparing for litigation or the thought of using the work product doctrine, you also have to simultaneously be thinking about obligations for litigation holds. And I know this is interesting for those of you who don't know, but I'm sure you do, what litigation holds are. These are policies by the company to make sure that documents are preserved. That means that if there is an automatic deletion of email set up on your company Outlook account, that needs to be deactivated so that evidence, emails, communications, documents can be preserved. People cannot just throw away documents that may be relevant. So in this instance, this duty to preserve evidence, this generally arises, even if there's no litigation currently happening, it arises as soon as you think there may be a potential for litigation or there is some anticipated litigation. Of course, I know the alarms in your head are ringing right now because that sounds a lot like the standard for work product doctrine. And guess what? Courts are realizing that as well. And they are starting to attach work product doctrine with this affirmative duty to preserve evidence. Now, the case law on this is very sparse, so there's not a lot out there. But what we do know is that increasingly kind of work product protections are being attached to the duty to also initiate litigation holds, which understandably would probably bring in business considerations. But it's something that you have to think about, because as this progresses further in the courts, there is definitely a feel that you may lose the ability to assert work product because there was not a litigation and hold in place at that time. So, moving on to the final privilege. Again, on the spectrum, self-critical analysis privilege is probably the more broader of all of the two privileges. But it's also probably the most complex of the two. It is not like work product and attorney-client privilege, one of the standard privileges well known through common law, through statutory support. It is one that goes by many names, whether it be the self-evaluation privilege or the self-critical evaluation privilege. Regardless, this privilege is used to protect self-critical assessments and subjective determinations by reviewing bodies, like safety teams or like product liability teams. So this privilege protects reports, summaries, and other documents created by these teams. Now, it's also important to note that this privilege will not protect routine documents or underlying objective data. And I think that's important to note, not just for the self-critical analysis privilege, but also for attorney-client privilege and work product. They're not going to protect kind of underlying data or routine information. But when you get to these reports and summaries that really get to self-assessment, really talking about sensitive information that gets at the core of why a product may have defaulted or why a particular incident occurred related to a product, the self-critical analysis privilege is very, very useful. The problem with this privilege is that because it's not one of those commonly known privileges, because it's relatively new, it actually just was used and recognized in courts about 30 years ago outside of the product liability context. It's one that the courts are very reluctant to apply. Again, how it applies jurisdictionally will change, and in some instances, how it's applied on the state level may even conflict with how it's applied on the federal level. I'll give you a few examples. So in Indiana, the state law is very clear. The case law is very clear. They say this privilege does not exist in Indiana, and no other privilege will exist in Indiana unless there is a statute and the state legislature makes it a privilege. Yet on the federal level, the state has used a more restrictive view or a more restrictive version of this privilege to protect certain documents that are mandated by government. And we'll get into that a little bit later. New Jersey is another example. Here, many of the state courts in New Jersey accepted the privilege. But then the Supreme Court disavowed the privilege on the state level. Whereas on the federal level, some federal district courts in New Jersey have used the much more expansive view that we're about to talk about, while on the Third Circuit level, they have yet to acknowledge or disavow the privilege. So again, you see how complicated this privilege can be. I think what's important to note as we move forward is kind of the basis for this privilege. This privilege was first established in the medical peer review context, and the idea behind the privilege was they didn't want to hinder candid conversations in those peer review sessions because people would fear that later in a potential litigation or wrongful death suit that information would negatively affect the hospital. The key behind why this privilege was started was concern for the public. So you want to incentivize candid safety conversations for the public versus incentivizing less candid conversations that would hurt the public. Since then, it's been used in Title VII employment discrimination cases, and in that context, it was used in the context of mandatory government reporting. And the idea was we want people to be candid about their policies, candid in their reports to government about their compliance with Title VII. without fear that in an employment discrimination lawsuit, their candid comments will then be used against them. So let's look at how this plays out on the federal level, the expansive view. So here, the privilege will apply if information results from a critical self-analysis. There is an interest in preserving the free flow of the information of the sort where the free flow would be curtailed if discovery was allowed, and the information was always intended to be confidential. Now, what's so important about this extensive view is, again, you're not going to be protecting routine safety information and safety reports, but you would be protecting reports and analysis after, say, a product has been recalled, and you're doing what you should do. And as Jeff talked about earlier, what is a part of a great product safety program is to really analyze, okay, what went wrong with this product? How do we make this product better? Without the fear of this coming to bite you during any potential litigation. So far, we've seen this play out, this expansive view used in the Ninth Circuit, New Jersey, Georgia, and the remainder of those states up there for your review. I won't list them all. So it has been established in a lot of jurisdictions. However, other jurisdictions have taken a much more restrictive view. And under this review, documents and communications can only be protected under this privilege if they're first required for a mandatory government report, and the policy has to the policy favoring exclusion has to outweigh the party's need for the document. And as you will see in our case study, this is not just, okay, we have a government statute that requires us to report certain things. Wham, we definitely fall into this restrictive view. It can't just be that it's required by the government, but the document has to actually, in some cases, be generated for that government purpose. So as you can see, Michigan, Indiana, Oregon, and Massachusetts have adopted a much more restrictive view of this privilege. But also what's interesting is there are some district courts that have both articulated, in some cases, the expansive view and also have utilized the restrictive view. So again, I think this all relates to how new this privilege is, how reluctant the courts have been to introduce it into instances where products are involved and product liability is involved. But I think this is one that we want to keep in our toolbox because it definitely can protect a lot more information, if applicable in the jurisdiction, than, say, a work product or a attorney-client privilege can. And it can do it before litigation becomes an issue. So on the state level, so as we talked about earlier in the presentation, the state level is usually guided by statutory guidance, or they use kind of the federal lingo to apply it on the state level. So what you will find a lot, and I think I would say the majority of the states, they would say no statute, no privilege. So a lot of the states are very reluctant on a state level to accept this privilege. And I've listed a few there for you to see. But some have done something a little differently, like Missouri. They've kind of relied on kind of statutes that allow this privilege for, say, insurance or for medical peer reviews, which, as we stated before, is how this privilege was initially created, to use this privilege on the state level. Whereas Virginia, they do not use it in a product liability context, but it is allowed in the medical peer review context. So I think what's important to note on the case laws, on the state law level, is that, yes, many states will not recognize this privilege. But there are plenty of states that where there are statutory support for this privilege in the insurance context or in the medical peer review context, they use that to then analogize it to a product liability context. So just be cognizant of that, and also be careful to look at the statutes, because many states, there are some states that have the self-critical analysis privilege codified in their state statute. And with that, I will turn it over to Jeff to talk about what this all means in the context of the role counsel should play.
Thank you, Lauren. And so, of course, we expect we're talking to a lot of lawyers and a lot of in-house lawyers who are thinking, what can we do? What role should we have? How should we use our outside counsel in this based on these various privileges? And we have a few ideas that are really sort of best case scenario, but one of them is lead the safety team. At the very least, have a legal department representative on the safety team. Make sure that its charge includes a clear legal purpose. Take it so it's somewhat not totally the business purpose of it, right? Include a legal purpose for what the safety team does. Make sure that the in-house counsel has a substantive role on it and is working in a legal capacity. All of those issues will help color the work of the safety team with a legal umbrella to increase the chances that there will be a privilege. And also, don't be afraid to use outside counsel. Outside counsel can work with the safety team for specific projects. I have been a member of a corporate safety team for certain charges or projects. And I think in doing that, it makes it a little easier to give it a clear legal purpose, to make sure that the outside counsel has a substantive legal role. Why are they there? What are they doing? If it's just to cloak it in privilege, the odds are that you're not going to get the privilege coverage that you want. And do it on the earlier side. Courts, I think these days, turn a skeptical eye to in-house counsel asserting privileges in such situations, but that skeptical eye changes when you involve outside counsel. And in all of this, both inside and outside counsel should work with the safety team to talk about their communications. Communication management amongst the safety team is very important, and teaching them the best ways to communicate are also important. And some of the things that I often lead with in this area is for people to focus on objective data and not subjective statements, and also to avoid particularly email that has preliminary off-the-cuff thoughts or theories. Those are the kind of things that, while we know that they're very initial, very early, and they're meant to start a conversation, they end up being some of the primary exhibits that get used against companies if these materials become public. So with that, as we've talked over and over again about how distinctive this can be state to state, how there are different standards applied, and how there are different privileges, we wanted to talk about a few specific case studies. The first case study is a self-critical analysis privilege case that involved a house fire that was caused by allegedly a defect in a furnace. And this one is interesting, I think, in large part because it involves reporting to the Consumer Product Safety Commission. So the question became, if we do have to report to the CPSC, what, if anything, is going to be protected by the privilege? And the company argued everything, that we have an obligation to report to the CPSC. It's government required. And if it's government required, the public policy of ensuring that we do a self-critical and honest analysis supports the privilege. So in applying the privilege, this court talked about 4 different prongs to assess it. The first is whether the materials have been prepared for a mandatory government report. The second was whether any privilege extends to subjective or evaluative materials. and objective materials. There was a definite distinction between objective and subjective. And lastly, the courts considered whether discovery had been denied only where the policy was favoring exclusion could clearly outweigh the plaintiff's need for the information. And what the court focused on here was they did want to encourage self-evaluation, but in doing that, the court said when you have objective data, that's not self-evaluation. Objective data is just that. It's objective data. So you're going to need to provide the objective data no matter what. If in reporting to NHTSA you include all of the warranty data for a set of vehicles, that warranty data is not going to be protected by the self-critical analysis privilege simply because you were required to report it to NHTSA. Also, information that was not prepared for the submission to the government agency is not going to be protected. So normally the mandatory reporting requirement for agencies has some sort of specific document that must be provided. Information that is not related to that document is not going to be provided. So again, if you submit a report to the Consumer Product Safety Commission, all the work that goes into that report, all the subjective work, is likely to be protected under the self-critical analysis privilege. But if you happen to have a safety team that has other subjective analysis that was prepared not for the CPSC report, that's not going to be protected. So you want to connect things to your government reporting requirement as much as possible. This next case study, it's a case out of the Northern District of Illinois from 1998. And what I found so interesting about it was the court starts with a long discussion as to whether there even is a self-critical analysis privilege and whether such a privilege should be applied by the federal courts. And the court does apply one, but really struggles with coming to the conclusion of whether there is a privilege or not. And I think as you read the opinion, it essentially decides we're going to apply the privilege, but we don't really see any authoritative precedence that says we have to apply the privilege. There's nothing out there in the law requiring it. There's not a U.S. Supreme Court case. There's not a statute. There's not a code. As a Northern District of Illinois case, there was not a Seventh Circuit case. It was really a study of different district court opinions from around the country, and I think really demonstrates how perilous it is to rely on the self-critical analysis privilege unless you're in a court that you know has already applied it before. This case involved injuries sustained while working on a rail train. The railroad then conducted an internal investigation and generated 2 reports. Here, the court looked at whether the analysis applied to both reports or one of the reports. And the first thing it looked at was this question that we talked about in case study number 1 about whether these were government mandated reports, because they were not. And so the court said, when you have a tort case, we're not talking about government reporting, and there's no government reporting requirement or government agency, that's not required. It's not required for the self-critical analysis privilege. However, the court still found there was no privilege, and in doing so, it set forth another standard, saying that the information sought resulted from a critical self-analysis. So that's first, you have to show that it was. That there's a strong interest in preserving the free flow of information in doing this for companies, which the court found that there was. It has to be, information must be the type whose flow would be curtailed if everyone knew there would be discovery. And then lastly, and this is where it really hit in the case, the document itself has to be prepared with the expectation that it will be kept confidential, and then is in fact kept confidential. And what I find so interesting about that prong is when we generally seek to keep information confidential, whether it be trade secret or otherwise, that is a key component of the analysis. Can we show from the very beginning that our organization wanted this document to be kept confidential and that we took steps to keep it confidential? If we do not proactively show that in the self-critical analysis, then that alone can lead to discovery of the material, and in this case, it did. So Lauren, I'll pass it to you for the next 2 case studies.
Yeah, so the next case studies are going to be examples for work product and for attorney-client privilege. So this is a case out of Nebraska, and this action was versus a truck manufacturer, and it came from deaths that resulted from brake defects. So in this case, the in-house counsel from the very beginning played a role in the investigation and the litigation preparation following the accident. And what the parties were looking for here were basically what the kinds of information we're talking about today. Investigation documents that came from the investigation team that took over after the accident, memoranda, notes from the investigations, conversations between employees and the different retained counsel. Here, the court looked at actually whether all 3 of the privileges apply, but we're going to focus only on the work product doctrine. And here the court made a distinction between ordinary work product and opinion work product made in anticipation of litigation. And here, their big thing was ordinary work product, the factual information made and created in anticipation of litigation was at the heart of what the plaintiffs want. And they said the plaintiffs had to meet the very high test under Rule 26 to rebut the presumption that work product didn't apply. And that was to say that there was no other way of obtaining this information without undue hardship on their part. And they were not able to do that. I think what is very important about this is that these documents, risk management documents, were created as a result of the attorney being a part of this case from the very beginning. But I think this is also a very interesting case because it's very fact-intensive in the sense that the court came to a lot of these conclusions after doing an in-camera review, document by document, of whether these documents were made in anticipation of litigation. Again, the focus wasn't so much on whether there was litigation on the horizon, but as long as there was an incident that could have caused a potential lawsuit or there was an investigation to avoid future lawsuits, the work product doctrine applied. Of course, they also said here where the documents did not reveal opinions or legal impressions, the work product doctrine would not apply. So again, that fact-intensive inquiry. I think what is also really interesting about this case is that this case had a very, very long history. And in that history, the party seeking work product, attorney-client, and self-critical analysis protection were actually the parties that did not follow through on a lot of their discovery protocol. So it's interesting to see that in this case they found that work product applied even though they weren't big fans of the counsel there. So for our final case, we were looking at the attorney-client privilege. This dealt with alleged defects caused by contact lens solutions. The plaintiffs here were seeking the root cause analysis from reports that were created after, again, post-recall evaluation. Here, the court, using California law, because that's what needed to be used under Federal Rule 501, felt that the presumption of the privilege applied here, and they upheld the claim because the attorney was involved, and you can tell that the dominant purpose was for legal advice. So we are at the point where you can enter your CLE code. I'm sure that this is what you've been waiting for. The code is RF30. again, if you could just enter that now so you can get your CLE credit, and then we will turn it over to Jeff to wrap up the presentation. Oh, so for our key takeaways, I think we've said this over and over.
I'm sorry, everyone. I'm here.
Okay.
Lauren, thank you. I had a slight phone malfunction. So I want to start by saying it may not be fully practical to implement all these key takeaways, but it's important to try and do as many as you can to preserve the privilege. And the first one is that you want to involve legal counsel, as we talked about. It may be as simple as involving in the document that gives the safety team their original charge a statement saying that the safety team is seeking legal advice from counsel for X. That alone can be a material difference in keeping your privileges. You want to, as we said, involve outside counsel early. You're going to increase your chances of having the privilege if they're involved in some way. There's going to be more of a presumption of legal advice. I think you want to make sure you have this legal purpose, differentiate between the legal and the business. There will definitely be multiple purposes. And I think this bullet point here about restricting information, that could be as important as anything. Emails get forwarded outside of your core group more than anyone wants to admit. And email is certainly an enemy to this whole process and keeping your privileges. So you want to be able to restrict, even if you use technological ways of restricting it, who has access to this information and be able to demonstrate what you did to restrict the info. Whether you set up email accounts for the safety team or email lists that only they have access to, however you do it, shared files that are restricted, something to maintain the confidentiality is crucial. And then when you do have your legal counsel involved, make sure they're giving legal advice. Make sure that they're not just doing grammatical changes and not on the phone adding nothing. Make sure there's always the legal component to your safety team meetings and it's being discussed. And then lastly, know your key jurisdictions. Know the law that you need to follow. Know what the rules are. Know whether this is even available to your organization. If you do all these things, you stand a much better chance at the end when you're trying to protect this information of successfully protecting it. And with that, Lauren and I thank everyone. I think we will, the line's going to be opened up for any questions if anyone has them. And we certainly would welcome any questions that there are. It appears that we have no questions.
Well, it looks like someone asked for the citations for the case studies. I can read them now, but we can also, I'm sure, send around an email with those citations to the participants if that's helpful.
Yeah, but we will follow up with citations to all 4 cases for everyone.
Perfect. I think that was the only question, but feel free to type in any questions you may have in that question and answer portion at the bottom of your screen.
But I think those are the only ones I see.
Yeah, that's the only one I saw as well.
Okay. If there are no further questions, we thank everyone for joining. And certainly if there are any follow-up questions anyone has after this, feel free to contact Lauren or myself. Our contact information is there. Thank you very much.
Thank you so much.